Hi, thank you for coming in today. It's so nice to meet you. My name is Shale Vandegrift. I'm going to be your social worker today. I am a social worker for Grace Hospice, and my role is to help you meet your goals. A few things before we get started. I need to go over some information that is very important for you. It is called informed consent, and it is pertaining to confidentiality and your rights. So if you have any questions as I go through these things, please don't hesitate to stop me and ask those questions. It's important that you understand what I'm going over prior to us being able to move forward in our meetings. Some of the things that we will be going over today, or I will be going over with you today, is mandating reporting, a duty to protect and duty to warn, records and how those are going to be kept and the confidentiality that pertains to them. And then if we have anything else any questions that you have after that point, then I will be happy to answer. So I'm going to start with what's called a duty to warn in the state of Texas. So a duty to warn is often pertains to if there is a conversation that you and I have during one of our meetings and it is clear that there's going to be harm that could take place to you or to someone else, then I would have a duty to warn that individual. In the state of Texas, however, confidentiality is protected and is looked at as being quite important between a clinician and their patients or clients. So with duty to warn, Texas has what's called a permissive standard, and I will read to you what that means. Texas social workers are permitted to warn of serious threats, but the permission to warn is limited to notifying medical or law enforcement personnel, not the threatened person or persons. So in that case, if there happens to be a conversation between the two of us where it is my understanding that there is a threat that you are making or a threat towards someone else, then I would need to notify the proper law enforcement personnel. So that is something that you need to know as we continue this relationship. Also, if I feel that you are at harm for hurting yourself, then that is also something that I would be mandated to report to the proper authorities. Another issue that we need to discuss is the mandatory reporting for child abuse. And this is under the Family Code in section 261.101, and this is a person's required to report. So as a social worker, I am a mandatory reporter, and I'm just going to read through these statutes so that they're clear as it pertains to Texas law. So a person having reasonable cause to believe that a child's physical or mental health or welfare has been adversely affected by abuse or neglect by any person shall immediately make a report as provided by the subchapter. Section B, if a professional has reasonable cause to believe that a child has been abused or neglected or may be abused or neglected, or that a child is a victim of an offense under that section, the professional has reasonable cause to believe that the child has been abused, the professional shall make a report no later than 48 hours after the professional has the first reasonable cause to believe that the child has been or may be abused or neglected or is a victim of an offense. A professional may not delegate or rely to another person to make the report, and of course the professional means an individual who is licensed or certified by the state, or who is an employee of a facility licensed, certified, or operated by the state, and who in the normal course of official duties or duties for which a license or certification is required has direct contact with children. And this would include clinical social workers or social workers in general. So in layman's terms, if there's ever a concern that a child may be hurt or is being hurt or neglected, then I am mandated to report that within 48 hours. In addition to that duty to report, a person or professional may make a report in the manner as applicable if the person or professional has reasonable cause to believe that an adult was a victim of abuse or neglect as a child, and that person or professional determines in good faith that disclosure of the information is necessary to protect the health and safety of another child or an elderly person. The requirement to report under this section applies without exception to an individual whose personal communications may otherwise be privileged, and that is including the social work relationship. The next mandatory reporting is regarding elder abuse. So the same situation applies with elder abuse as does with mandatory reporting for child abuse. If there is communication between the two of us where I feel that an elder is at risk for being harmed or neglected, I am mandated to report that within 48 hours. Okay, moving on. So regarding the Texas Health and Safety Code, so this is pertaining to the confidentiality of our confidentiality pertaining to our conversations and records. So according to the mental health records in Texas, the confidentiality of information and prohibition against disclosure. So communications between a patient and a professional and records of the identity, diagnosis, evaluation, or treatment of a patient that are created or maintained by a professional are confidential. Confidential communications or records may not be disclosed except as provided by section 611.004. No exceptions to the privilege or confidentiality under section 611.004 may be construed to create an independent duty or requirement to disclose the confidential information to which the exception applies. This section applies regardless of when the patient receives services from the professional, and I will get to that section in just a minute. Persons who may claim privilege or confidentiality, this would be the patient, a person listed who is acting on the patient's behalf, or the professional, but only on behalf of the patient. And then the authority of a professional to claim the privilege of confidentiality on behalf of the patient is presumed in the absence of evidence to the contrary. So you as the patient or an authorized representative, and of course if you were a minor, then parents or whoever was legally responsible for you would be considered the person having right to confidentiality. Now, statute 611.004 gives the information about disclosure of confidential information, and so these are the situations that confidential information would need to be disclosed. So a professional may disclose confidential information only to a government agency if the disclosure is required or authorized by law, to a medical, mental health, or law enforcement personnel if the personnel determines that there is a probability of imminent physical injury by the patient, to the patient, or others, or there is a probability of immediate mental or emotional injury to the patient, to qualified personnel for management audits, financial audits, program evaluations, or research in accordance with subsection B, to a person who has the written consent of the patient or a patient if the patient is a minor, or a guardian if the patient has been adjudicated as incompetent to manage the patient's personal affairs, to the patient's personal representative if the patient is deceased, to individuals, corporations, or government agencies involved in paying or collecting fees for mental health or emotional health services provided by a professional, to other professionals and personnel under the professional's direction who participate in the diagnosis, evaluation, or treatment of the patient, in an official legislative inquiry related to the state, hospital, or state school as provided by subsection C, to designated persons or personnel of a correctional facility in which a person is detained if the disclosure is for the sole purpose of providing treatment and health care to the person in custody, to an employee or agent of the professional who requires mental health care information to provide mental health services, or in complying with statutory licensing or accreditation requirements if the professional has taken appropriate action to ensure that the employee or agent will not use or disclose the information for any other purposes and will take the appropriate steps to protect the information. And finally, to satisfy a request for medical records of a deceased or incompetent person. So in most cases, confidentiality is upheld between us in our meetings, but there are those circumstances where I would be required by law to provide the appropriate people with that information. Authorized disclosure of confidential information in judicial or administrative proceeding. So a professional may disclose confidential information in a judicial or administrative proceeding brought by the patient or the patient's legally authorized representative against a professional, including a malpractice proceeding, and a license revocation proceeding in which the patient is a complaining witness and in which disclosure is relevant to the claim or defense of a professional. A judicial proceeding affecting the parent-child relationship, any criminal proceedings as otherwise provided by law, and a judicial or administrative proceeding regarding the abuse or neglect or the cause of abuse or neglect of a resident of an institution as defined in Chapter 242. A judicial proceeding relating to a will if the patient's physical or mental condition is relevant to the execution of the will, and involuntary commitment proceedings for court-ordered treatment. And I will make sure to give a list of this all to you so that you can review it as well and become more familiar if you wish. Now, revocation of consent. So, except as provided by subsection B, a patient or patient's legally authorized representative may revoke a disclosure consent to a professional at any time. A revocation is only if it is written, dated, and signed by the patient and legally authorized representative. So if you happen to allow someone to have access to your records and then decide at a later time that you do not wish to have them have access, then you can revoke that authorized representative. A patient may not revoke a disclosure that is required for purposes of making payment to the professional or mental health care services provided, and a patient may not maintain an action against the professional for a disclosure made by the professional in good faith. Reliance on an authorization if the professional did not have notice of the revocation. And finally, as requested by the patient. So upon receipt of a written request from a patient to examine or copy all or part of your records, a professional is required to provide it as promptly as required under the circumstances, but no later than the 15th day after the date received. So if you do wish to have a copy of your records, you have access to those. They would just need to be made in a written format, and I would be able to provide them to you. Are there any questions? I know it's a lot of information, but do you have any questions pertaining to any of that? Okay. Please let me know if you do. And I'm going to have you sign a notification that I have informed you of your rights, and that will go in your file. And if at any point you do have questions, then please let me know. I look forward to being able to work with you. Thank you so much.